So my presentation is based on a paper that I co-authored with Gábor Halmai, and it is a case study on Hungary. And we sought to address the question of why the Hungarian judiciary remained mostly silent when the Orbán government, which has been now in power since 2010, gradually dismantled judicial independence. So we look for the reasons for the low level of judicial resistance in Hungary. And we assumed that judges' freedom of expression can be a very important tool for judicial self-defense in autocratizing countries. And therefore, we looked at the legal and institutional framework to better understand why there were little resistance among the Hungarian judges. And we claim in this article that judicial independence cannot be fully restored if the possibility for judges to speak up or speak out is not guaranteed, and this right is not exercised effectively by the judges. So we also urging for a need to change the Hungarian approach and the mentality of the judges in using their freedom to speak for their own independence. And I would like to start with I don't know how to move the slides. Sorry. Is it fine now? Okay, yeah. So of course judges speak primarily through their decisions and judgment and through their official reasonings. And it is on the bench where they can primarily defend their own autonomy. And I brought a recent example from Hungary. It's a very new one, when a court annulled a fine that was imposed on a bookstore, on a bookseller, for violating a very controversial anti-LGBT plus law. And the problem was that you can see the book, The Good Night Stories for Rebel Girls, which is a children's book, and it contains very short stories about inspiring women who can be a strong female role models for young girls. And the problem was that this book was not distributed in a closed packaging, which is required now, this law, this anti-LGBT law, because it is considered to portray sexuality and gender reassignment and sex change in a self-serving way. Because you have to know that this book contains very short stories, and there is one single story on a transgender girl, and this was the problem. And the court annulled the fine that was imposed on Lira for violating this anti-LGBT law. And according to media reports, because it's a very recent case, so I haven't seen the official reasoning, but according to media reports, the court argued that this book is very far from being self-serving and portraying self-serving sexual content. And it's actually addressed the problems and the issues of the 21st century. So there is no, it would be unreasonable to accuse it of being threatening to children. And this is one single example for how judges can defy a legislation which is unreasonable, and how they can provide a human rights friendly interpretation. But we also know, at least from the Hungarian experience, that it's very difficult to resist on the bench. And it can be also very risky and costly for judges. On the one hand, because these autocratizing countries or autocratic countries are heavily based on the formal legitimacy of the law. So it would be very difficult for judges to challenge the legal framework on a daily basis. And on the other hand, there are some traditional legal avenues which are no longer open for judges. For instance, in Hungary, just to give one example, the Constitutional Court is packed and politically captured. So it's no use for bringing complaints before the Constitutional Court. So on-bench resistance is difficult and risky for the judges. And therefore, we hypothesize that under these circumstances, off-bench resistance gains special relevance and significance in the legal system. And we checked this, and we checked how freedom of expression can have off-bench resistance among the judiciary. And we looked at the legal framework, also on the domestic jurisprudence. There is very few cases which tackles and discusses the question of how the freedom of expression of judges should be protected. What is the scope of the freedom of expression of judges? But we try to look into it to get a gist of the judicial understanding of what it means to exercise their right to freedom of expression. We also looked at the institutional context. I will talk about it because I think it's very, very relevant, and also analyze the role of European courts and whether they were capable of empowering domestic courts, empowering specifically Hungarian courts in speaking out and speaking up for their own independence. And what we have found during this research is that the legal framework, which consists of old rules, dates back to the 1989, to the previous regime change, they portrays a very, very restrictive legal framework. I brought just two examples. The first one is that how it deals with judges' political engagement. I mean, there is a clear ban on judges' party membership and political activity in Hungary. And it is also entrenched in the fundamental law as well. So the law claims that judges shall not be affiliated with any political party or engage in any political activity. But this law fails to define what political activity means actually. And of course, under this scenario, it's very relevant what was the historical experience, how judges in general are socialized in the Hungarian judiciary. And this very categorical ban without any guidelines, what does political activity mean, can be very harmful for judges to use their right or to exercise their right to freedom of expression. And this ban was also indirectly, at least confirmed by the European Court of Human Rights, when it stated, I mean, the court stated with regard to a case of a police officer that these kind of prohibitions and bans can be legitimate and can be proportional, at least in a period when there is a transition to a full democracy. But, you know, the previous system, I mean, the state socialist system ended more than 30 years ago, and this categorical ban is still on the statute book, and it can be very harmful for the judges in terms of how to understand their possibilities to speak out or to engage in public debate over questions of judicial independence. And there is a very similar, very restrictive overbroad restriction on how judges can comment cases. If you just read the relevant text, it suggests that judges are not allowed to talk about any kind of court cases, even not even about those that have been already closed. And what we have found is that these bans or restrictions go far beyond what has been set down or laid down by the European Court of Human Rights in previous years. Because if you just look at the jurisprudence, of course, the Baca case can be very relevant. Judges are not prohibited from talking about issues of the judiciary, about judicial reforms, and these kind of speeches are highly protected due to the jurisprudence of the Court of Justice. So we found a very restrictive legal framework which can discourage judges to use their right and to speak for their independence. We also looked at the domestic jurisprudence, and as I mentioned, there are very few cases. So it's a question to what extent can we make general statement on what we have seen. at least we can see some kind of progress in terms of how judges in judgment see the scope of their freedom, or to what extent they are entitled to engage in public debate on issues that are relevant, that affects their independence. So, for instance, there is a case which is not strictly about the freedom of expression of judges. It's a defamation case brought by a judge who was subject to smear campaign by pro-government media. And in this case, the court found that if a judge publicly criticized court administration, for instance, cannot be considered as a political activity, which is, looking at the Hungarian context, can be seen as a progressive finding. Or the same judgment held that judges can participate in professional events, in conferences, and even they can participate in projects of human rights NGOs. And in Hungary, human rights NGOs today are really stigmatized and labeled many times as foreign agents. So if we know this background, we can see that the judgment made some very progressive statements concerning what is allowed for judges in terms of addressing politically cases that can, or issues that can have also political implications. Okay, and I want to say a very few words about the system of court administration in Hungary, because if I move back to one of my slides, you can see that we also looked at the institutional context and the power dynamics within court administration, and on what are the approaches that different actors in court administration advocate. And it is important to note that from 2012, a new model of court administration was established, which contains the National Judicial Council, but it's not a council model. It's not a model of self-governance, because the council was for a long year very weak, at least in terms of its formal powers. And as I want to talk about what the Judicial Council advocated during these years when it has no effective power in court administration, it is important to understand that for a long time, it was at least formally a weak player in court administration. However, and I think this is something that can be a good lesson for all other jurisdictions, the National Judicial Council sought to advocate for and promote a new approach, a more permissible approach to judicial free speech. It started to make public statements when they felt that there is a threat on judicial independence. And they became a kind of strategic actors in this regard. They also created their own website, and they started to publish the minutes of the meeting. So the transcript of the meeting, which was also beneficial for being transparent, but it was also for reaching out to the larger public, to reach out to the professional audience, to make the problems of court administration, the attacks against judicial independence visible for domestic stakeholders and international stakeholders as well. And they also adopted a new code of judicial ethics and included a very important provision which states, as you can see, it's Article 4, paragraph 2, that judges can freely express their views on the law, the legal system, on court administration, and in particular, they can publish, give lecture, and teach. And it's clear, however, it was never officially stated, but it was a response to the Baca judgment. It was a kind of implementation of the Baca judgment. So there is a clear effort on the part of there was a clear effort on the part of the council to provide a higher level protection for judicial free speech. And of course, the question is that to what extent can we talk about a success? And the results are mixed, because on the one hand, the EU pushed through a judicial reform in 2023, so last year, which strengthened the powers of the council. If we just move back to the previous slide, we can see now that the council is a more powerful actor. However, it's still not a system of judicial self-governance. But the position and the powers of the council has been strengthened. So it's a success, and it is a success of how the council uses its right to speak out and to engage in public debates on the problems of judicial independence. But what is not a success is that the new code they adopted was challenged by the president of the Korea for being not in compliance with the legal framework and the fundamental law itself, for providing too broad protection for judicial free speech. And this case is still pending before the Constitutional Court now almost for 2 years, which gives a very uncertain situation for judges, because the code, which is in effect now, contains a provision that they are allowed to talk and they are entitled to talk about problems of the justice system. However, the Korea president, the Supreme Court president, opposes this idea, and the Constitutional Court seems to be intentionally delaying to address this issue and deal with this complaint. And there is also the problem, which is typical in autocratizing countries, that if there is an actor, a court, a judicial body, which seeks to challenge the system, it is a risk that it can be accused of entering the political arena, and it can be accused of engaging in political activity. And this has happened with the council as well, because it had to face a lot of attack from a lot of anger, from a lot of direction from the government, from the judicial leadership. I mean, the main actors of the court administration, or the other actors of the Central Court administration, and they were subject. I mean, members of the National Judicial Council were subject of smear campaigns by the propaganda media many times. Just to give you one example, when judges, I mean, members of the council, in their official capacity as representative of this council, of this constitutional body, they met with the new US ambassador to Hungary. There were, I mean, it is the analysis of the Helsinki Committee, more than 400 discrediting material published in pro-government media over 1 month. So more than 400. And of course, these attacks can have a chilling effect on other members of the judiciary. And perhaps it can be a reason why this new approach that was advocated by the council could not prevail in the judiciary. And we also looked at the role of the European courts. And I know that I'm approaching the end of my time. And what we have found is that there were only very few cases which dealt with problems of judicial independence in Hungary. They did not address these problems as systemic problems. And although the Baca case is very famous, what we have found is that this case was more relevant in a doctrinal sense than having real practical effect on judges' freedom of expression in Hungary. We can say that the council relied, or implicitly relied, on the findings of the Baca judgment when they amended the Code of Judicial Ethics and inserted this provision I have shown to you before. But in practice, we haven't seen any clear change in how judges see their possibilities to speak for their own independence. And to conclude, what we have found in this study, that there is no clear shift from the old approach. And the legislative framework is very harmful for the Hungarian judges. And there is no substantive change in the judicial understanding of judges, the scope of judges' freedom of speech. And it can be attributed to a large extent to the power dynamics in court administration, as the council was not a very powerful actor for a long time, at least formally, and other court leaders attacked the Judicial Council, and they sought to marginalize and discredit this new approach that was advocated by the Judicial Council, often accusing the Council of politicization and accusing it for being political and in engaging in political activity. And what we have also found that the potential for mobilizing judges at the domestic level seems to be still weak, but the transnational judicial system, the European courts, the Court of Justice and the Strasbourg Court did not provide enough support for the Hungarian judiciary, because as they failed to address these problems of judicial independence, a systemic one, of course, the gravity of the threat that judges have to face is masked, is not clear, is not evident, and therefore judges are not really encouraged to speak up for their independence if there is no support from the transnational level. Okay, so this was more or less our conclusion and main findings for the reasons of the low level of judicial resistance in Hungary since 2010. Okay, and I will stop here and thank you very much.